All right, hi everyone. Welcome back. Welcome back. How's everyone doing? Good, good. Hopefully everyone had a nice break for me on Monday. Hope you enjoyed it. Probably not as much as no, just kidding. Yeah, that's not working right. So I almost want to turn it off so it's not distracting. Yeah, I'll call some about that later. I don't know why it's working that way. Okay. Let's see. What's new? Any questions? Anything on your mind? Anything lingering in your thoughts? I was invited to give a speech. So Forbes magazine does this ranking of the 30 people under the age of 30 in different categories, and I was selected for law and policy. So I was invited to give a speech there, which was actually kind of cool. I don't know if you read about it last night, but among other things, Monica Lewinsky was one of the keynote speakers. And you probably saw this news. She gave a pretty powerful speech about cyberbullying. And you may not think about it, but she claimed she was victim zero for internet harassment, which is probably a fair statement. So she was there. Actually, Malala, just won the Nobel Peace Prize, was there, but I couldn't see her because I had to come home to teach you early. So I missed her for you, which was well worth it. Well worth it. My flight was actually delayed an hour, so I was actually really annoyed because I could have seen her, but I didn't realize that at the time. I also gave a talk at UPenn, some other stuff, so that's why. I tried not to cancel class, and I wouldn't have gone to this, but asked me to speak on millennials and politics. So I encourage all of you to go vote. If you don't already know this, early voting. It's very easy. There's actually a place on Gray Street about 2 miles from here. They have a parking lot. You go in, you go out, it takes 5 minutes. Don't wait till election day, because if you do, you're going to have a long line saying, nah, I don't want to do it. So you're all intelligent, smart people who have knowledge about the law and are implicated. So go vote. It's your duty as a citizen of the republic. You know, Benjamin Franklin was famously asked, "What have you given us? What is this?" And he said, "It's a republic if you can keep it." And one of the ways we can keep our republic is by voting. So go vote. All right. What else? What else is on your mind? No? All right. Let's talk about property then. Okay. All right. And yeah, so I don't know what's up with that thing. I turned it off. I'll call some about it later. So today we're going to be discussing a topic of marital property. So this topic will stretch a few different classes. One of the reasons it will stretch a few classes is that there are two primary approaches to marital property. There's what's called common law property, which is a system in about 42 states. And there's something called community property, which is a system in 8 states, including our fair republic here in Texas. And the differences are actually quite significant. So you need to pay attention to both of them. And even if you don't even care about common law, you say, oh, I'm only going to be a Texas lawyer. You have to know that when people move between states and they bring with them property from another state, the property often retains its initial characterization. So you're going to need to know both of these. You can't simply say, oh, I only want to know one. You'll have something of a leg up on other people because you'll have a much deeper knowledge of community property, which is not well taught in other states. I don't think I even learned it when I went to law school. So you'll learn both, and you'll get a pretty good knowledge about them. Okay. All right. So before we get too far into it, let's review briefly our discussion on concurrent interest. Right. We discussed that there were 3 different kinds of concurrent interest. Right. There was the tenancy in common, there was the joint tenancy, and there was the tenancy by the entirety. Right. Those were the 3. And I told you deliberately, don't worry too much about the tenancy by the entirety because we'll spend an entire class on it. My friends, that class is here. But why do we have these concurrent interests? Like, what is the rationale for these concurrent interests? Well, it allows 2 people to have a same claim to a piece of property. Each party has what we call a separate but undivided interest, right? I urged you strenuously, do not think that they own it 50-50 because that's not the case. They each have a separate interest in the entirety of the property. And that doesn't change regardless of who is owning it, whether it's husband and wife or just friends or roommates. Okay. We also discussed this idea of unities, right? How the law wanted to protect people who were able to keep and acquire the property together. So the joint tenancy requires 4 unities to be present, right? Remember T-tip, time, title, interest, and possession. You have to have those memorized. Just know them. If the 2 parties acquired at the same time, they use the same title, that is the same instrument. They have the same interest in the land. For example, if they both have fee simple, or they both have life estate, it has to be the same. And the final one is possession, right? What do we mean by possession? They each have to have access to the entire property as a whole, right? They can't have a fence put up or any kind of way to block people off, right? So time, title, interest, and possession. These are the 4 unities. Are any questions on that? And we discussed, generally speaking, when you have a joint tenancy, one of the parties can sever the tenancy at any time. If one of the parties conveys his interest, right, that breaks apart the time and the title unity. And as a result, the joint tenancy is severed and it becomes a tenancy in common. So one of the joint tenants can frustrate the whole. He can do certain steps to break apart these unities and make it so that there's a tenancy in common. The cost of doing this, though, is steep. One of the great benefits of the joint tenancy is what's called the right of survivorship. That means when one tenant dies, the other one gets automatically. It doesn't go to the tenant's heirs. By severing the unities, you are now able to destroy this right of survivorship, right? And then it goes to the person's heirs when they die, right? So that's one of the costs of it. We also did a case involving what interests or liens can be put on property. We did the one case where, remember the husband and the wife with the almond trees, right? And he leased out part of the property to build a boxing pavilion, right? And with a joint tenancy, there's really nothing wrong with that. One of the tenants is allowed to lease out the land, right? He may be liable to pay rent to the other tenant, but they're allowed to do this. Ditto, we discussed cases involving mortgages, right? How one of the joint tenants can actually mortgage a piece of property without severing the unities, okay? So even though they're joint tenants, they can still do certain things to put restrictions on how the land is used. All right, any questions on that? All right, today we're going to be discussing the third of these types of concurrent interests, which is the tenancy by the entirety, okay? The rules for this one are a bit more complicated because of the history behind them, right? And the history is actually somewhat important. So let's talk a little bit about history and marriage and how marriage worked for many years. You know, today one of the most significant legal topics of our day is same-sex marriage, and this is a topic that has evolved with a velocity that I could not have anticipated. I've now taught this class 4 or 5 times. I've lost count, and each time I teach this unit, I have to drastically rework the same-sex marriage issues, right? So I'll get more to the same-sex marriage issues a little later. But one of the reasons why this issue is so controversial has been because of the significance of marriage throughout much of Western civilization. Now, marriage is often called this institution, which is a phrase people use, and you probably don't even know what it means. But institution means it's a cornerstone of how society was developed, right? And specifically, it was a way of dealing with property, okay? So historically, right, going way, way back, women were not allowed to own property. They weren't. They were not entitled by law. Also, poor people could not own property. There were various restrictions beyond just gender. People of color couldn't own property. There were lots of restrictions. But women in particular were not able to own property. Yet, you'd often have wealthy families who wanted to ensure that their daughters were taken care of and they had certain protections, right? Often, in fact, almost always, women would get married, right? So how did the law deal with a situation where women couldn't hold property, but you saw these wealthy fathers who want to leave land to their daughters so that their grandkids and whoever else can get it? So there was this creation of a legal fiction, okay? What do we mean by legal fiction? It was said that when a husband and wife were married, they created a new person. What do you mean? When the husband and wife were married, they were no longer only considered two people. It was actually the creation of a third entity, right? This is a legal fiction. Of course, when two people get married, there's not some third person that spawns out of nowhere, right? But the law treated it as if a new person was actually born. Call this the married person, right? All of the property held by the husband, whatever he may have owned, and by the wife, perhaps whatever she may have inherited, was now deposited into this fictional third person. Okay? This was called coverture. I'll spell it out, it's a word you may not have seen. Married with Children, right? Frank Sinatra, Love and Marriage, and Suit You Can't Disparage, right? So the institution was called coverture, okay? And literally, it meant that the property was under the cover of this married entity, this new married person, okay? Think of it almost like a trust, right? Where if you have a bunch of people who have certain wealth, they deposit in a trust, which is really for the management by a third party. Okay, but the reason why this was a fiction, right, is because only one of the parties was able to do anything with the property in this fiction. The husband. To be more precise, you would say the property of the woman was under the husband's cover. That's where the word coverture comes from. The husband literally covered the wife's property. So during the marriage, right, during the marriage, the wife had no control whatsoever over any of the property, right? Say her father had left some will to go to the father left some land to go to the wife when the father died. That land would now be deposited inside this little fictional arrangement, but the husband would have complete control over how that land is used, who lives on it, whether it's bought or sold. Okay. So at every juncture, any land a woman may have obtained while she was married would be deposited in this grouping. Okay. But why was this fiction essential? Think of this situation. What happens if the husband dies? What happened to all the land the wife had inherited? Does it just disappear? The wealthy land barons would not have liked that. They wanted land to stay in their family. So actually what happened was, when the husband died, this fictional arrangement dissolved, and whatever property the woman may have held undercover goes to the woman in fee simple. I say that again. Once the husband dies, this fictional arrangement disappears, and the wife gets whatever property she had before or that she may have inherited during the marriage. This was set up to basically make sure while the wife was married, the husband would manage all of her affairs. But once the husband dies, he dies early, the woman would now have whatever property she has, and then she could perhaps go get remarried or whatever else with that wealth. So if you think about it, before the woman was married, she had whatever property interests. When she gets married, it all gets put into this coverture, and then when the husband dies early, it returns to the wife.
If she remarries, the longer coverage for the new husband?
Exactly. So if the woman remarries, same deal. Married women were not allowed to hold property, and it would then go under the husband's cover. And if this woman was very unlucky and her second husband dies early, it would then return to her. Right? So I use this word cover as almost like a euphemism, but it was really viewed that while the woman was married, the husband would basically control the property, but if the husband died, it would leave. Okay? Yeah. they can inherit property. When in the absence of primogenitor, right? Meaning primogenitor means only the firstborn son can acquire property. Women were allowed to inherit property from their fathers or whoever else. And they could not really sell or alienate it, though. Right? So you want to think about it in terms of the bundle of sticks, right? They could inherit property, and it would probably be for some sort of limited purpose. They couldn't actually sell it, right? So let me be precise. Women could have property they inherited. They weren't allowed to buy or sell a land. Okay? So one of the interesting things about marital property is that while the husband and wife are married, in theory at least, not in reality, but in theory at least, the marital property regime doesn't matter, right? In the same way that we say joint tenants have a separate but undivided interest in the entirety of the land, the same applies to married couples. The husband can't block the wife from entering part of the land, right? The husband can't do anything to the detriment of the wife. So during the marriage, it doesn't really matter who owns what, because each have a separate undivided interest. But again, that's a fiction, right? Because we know that the only party that was able to enter into any transactions to sell the land, to put a mortgage in the land, to lease the land was the husband. So on the one hand, they said that the husband and wife had an equal interest in the land, and they had it in its entirety together. That's what it means by the entirety. But in reality, only one party was able to mortgage the land, use it as credit, or hire any lessees. Okay? So much of the tenancy by the entirety doctrine was based on creditor law, right? Was based on debt. So a common law, say the husband puts a mortgage on his property, right? He doesn't pay. Okay, what happens? They try to collect on the land. Did the wife consent to this mortgage? No. But a common law didn't matter. Since there was only an entire estate, there was no separate interests, when the husband committed a mortgage, right? He didn't just commit a mortgage on his share, he committed on the entirety of the estate. So a creditor could easily go and seize the entire property and put it up for sale, even though the wife had nothing to do with it, right? This is similar to the case we did last week with the with the almond groves, where the one husband could lease it out without the other one's permission. As you can imagine, this became very unpopular because you had all these married couples, and the husband's an idiot and go put some mortgage on it. The wife has no idea what's going on, and then randomly the husband defaults when he was a gambler or a debtor or whatever else, and then they show up and foreclose their house, and the wife is out of a home, right? So as a result, the law started to change, right? And while in hindsight, we may look at this as a gender equality movement or a way of giving women property rights, I think we need to be very careful in how we describe what happened, right? They mentioned that Mississippi in 1939 passed the Married Women's Property Act. Now, I don't mean to offend any of my friends from Mississippi, but this wasn't exactly the most progressive state in the Union, okay? They didn't decide to give women property rights because they wanted to promote suffrage and promote equality. No, let's be very careful. The Married Women's Property Act had the effect of allowing women to own property while they were married. So now married women are allowed to own property, okay? So let's think about what this does to the tenancy by the entirety. Before this law, we said that the husband and wife owned it as an entirety. There was this fiction, right? And if any mortgage was placed on the land, it wasn't placed in separate but undivided shares. It was placed on the entirety of the land. Everyone get that, right? Before this law was passed in 1837, any mortgage was placed on the entirety of the land. Okay? But now it was different, right? It's different now. How is it different? The husband has a share, and the wife has a share. They each have a separate but undivided interest while they're married. This law eliminated this fiction of coverture, right? It got rid of coverture. Now it was the case that each husband and wife each had a separate, a separate share in the land. Okay? When this happens, debtor law becomes very different. As a basic right, you can only put a mortgage on your share of the land. If you walk into a bank and you're, say, a joint tenant, right? And you say, hey, I want you to give me a mortgage. They say, okay, we'll give a mortgage only on your share of the land, but we can't basically put a mortgage on your roommate's land, on your co-tenant's land. So imagine what happens here. The husband walked into a bank and he put a mortgage on the entirety of the property as an entirety. Then this law is passed, right? This law is passed. Did the bank ever have a security interest in the wife's share? The answer is no. The husband can only provide credit for his own share. The bank cannot seize the entire property. They can only seize the husband's share. And as you may imagine, it's not very profitable to try to sell a separate interest. You want to sell the entire lot. So imagine another example, right? Husband and a wife own a piece of property in Mississippi in 1840. Husband's a debtor, has lots of debts. So the creditors come after, hey, we want to seize your property. We want to seize your land. He's like, hey, you can seize my interest, but you can't seize my wife's interest, and therefore this property is not very valuable to you because you can't force a sale, right? No one will go to a sale and buy a joint tenancy to live with, the missus of the home, right? No one's going to do that. So while this may seem like a massive law that was aimed at promoting, giving women property rights, it really wasn't. It was a way of shielding homes from creditors. So now creditors could not seize and attach the entirety of the land. They were stuck to only seizing the husband's share. Everyone see that? Any questions on that? It's more of a tricky concept, but not too bad. So that's the important historical background for tenancy by the entirety and the Married Women's Property Act, right? It was very often the case that now land was being shielded from the creditors. I actually checked this up. Texas passed one of these laws in 1840, which was actually much more progressive than Mississippi's. It said that married women can now enter into contracts. Married women in Texas can now write wills. They can actually sue for divorce. You may not realize this, but for much of history, only the man could petition for divorce, not the woman. She could also veto the sale of her property. In other words, if her husband was trying to sell the homestead, she could stop it. And they had also other protections for what we not call alimony or spousal support, if you will. Is that hand up somewhere? Okay. So, right, awesome, right? We have this Married Women's Property Act, right? It gives all these rights. It was actually fairly limited because for all intents and purposes, the husband remained the head of the household. And women who, at the time, virtually had no work, they didn't actually work outside the home, did not have the means of actually acquiring property in the absence of inheritance. So this was mostly a means of allowing women to have any kind of property owned that they may have inherited. Okay. All right. Questions on this? Okay. I'll take a brief 1-minute detour and talk about some issues of women's suffrage. So we often think of the suffrage movement as primarily about the vote. And you might have read about the Seneca Falls Convention of 1848 with Elizabeth Cady Stanton and Susan B. Anthony. And they actually had this thing called the Declaration of Sentiments, which I would encourage you to read. I have the highlights up here. And these sentiments were effectively ways of saying that the women are treated unequally. And it wasn't simply about the vote, right? So one of them says, quote, "He has made her, if married, in the eyes of the law, civilly dead," which isn't very much true. When you were a single woman, you were allowed to hold certain properties you may have inherited. You could do whatever you wanted for the most part. But once you were married under coverture, this was eliminated. Okay. This one says, he has taken from her all rights and property, even to the wages she earns. Okay. In many states, women were not allowed to actually even earn a wage. Any wage they may have worked would actually be paid directly to the husband or something like that. This one is very relevant. He has so framed the laws of divorce as to the causes of divorce in case of separation that the woman has no say. So for much of history, it was the man who decided when a petition for divorce was filed, and the woman could not get one herself. These laws were gradually changed to allow women to petition for divorces in cases of abuse or abandonment. Those were actually fairly novel inventions in the law. More importantly, in the 20th century, we've seen the advent of the no-fault divorce. We don't have this. California has the most extreme one, where effectively either party can petition divorce at any time without any cause. And in other words, through no fault of their own, they will offend irreconcilable differences. That's what they usually say. Okay? Any questions on that? All right. So even that didn't get too far. So you might recall the 14th Amendment, which was passed in 1868, was largely silent on the issue of gender. Specifically, it speaks of persons, but it doesn't say whether there's a scrutiny, if you will, applied to gender discrimination. You say this in common law, I think. Most notably, Susan B. Anthony decided that she wanted to vote, and she walked into a polling precinct, and she said, hey, I want to vote. And the polling precinct said, oh, you can't do it. Women are not allowed to vote. She said, hey, wait a minute. 14th Amendment says all persons, right? I'm a person. I can vote. And what's fascinating about that is she actually persuaded the polling official to let her vote. The court reversed her, though, and they actually made the point of saying that the 14th Amendment specifically references male suffrage. It says basically proportions, whatever, but it says men can vote. And they also made the argument that if the 15th Amendment was required to give blacks the vote, why would you not need another amendment for women, right? If the 14th Amendment, by virtue of equal protection, gave women the right to vote, why we need a 15th Amendment to give blacks the vote? So it wasn't until the 19th Amendment was ratified many years later that suffrage was given. So an interesting other issue to think about while we're on this topic is after women were given the right to vote, did that change other aspects of our legal system? For example, women allowed to serve on juries. So in a number of cities, the jury roster was pulled from the voter registration rolls, right? So they basically made whoever could serve on jury based on the voter rolls. So now that you had women who were on the voter rolls, could they now vote? It was actually a significant amount of litigation about that because no one had ever defined who could actually serve in a jury. They said only if you're a registered voter you can serve in a jury. And eventually, most of the places changed the laws in this respect. But there's a long-standing issue about women and property rights. And it's fascinating that it took debtor and creditor relations for property to effectively give women the rights to have property. It's an odd history, but it's fun to think about. Okay? All right. Any questions about that? Any questions in that history?
Wait, I have a quick question.
Mm-hmm.
On your blog, I'm like, yeah, I'm gonna go to class, and it comes up with class 18. And
If you scroll down, class 17 is underneath it.
Really?
Yeah.
Okay. That's
Keep on scrolling.
Okay.
Keep on trucking, if you will. Yeah, I think because I canceled the class, I messed up my scheduling. So you may not know this, but I actually I schedule my posts in advance. So if I die, my blog will keep going for about a month. It's actually a scary thought, but I write blog posts well in advance. So I forgot to change the schedule, so I canceled this one. So I think we're one day off. So just keep scrolling down. But it is a scary thought. Something happened to me, my blog would keep going. It's a weird thought. I have some post schedule up pretty far. Anyway, actually, it's funny. I scheduled a post for the year 2015 about hoverboards, saying, "Where's my hoverboard? I want one already." And it was funny. If you read the New York Times this weekend, there's actually a company that's on Kickstarter, and they're generating a hoverboard that can hover about an inch above the ground. Unfortunately, it works on metal tracks, which is not quite cool enough. It won't work on water, though. You can't work on water unless you have power. Right, you need power. So if you don't know what I'm talking about, go watch Back to the Future 2. Okay. All right. Other questions? Actually, when I was a little kid, when we went to Universal Studios, I saw them filming that. They actually had these huge cranes. I mean, the thing with the hoverboards was they weren't all computerized. They actually had these little plastic boards and these huge cranes that would zip them around. And that's how they created the effect. And they would scrub out the cables in the post-production. So I remember that somewhat vividly when I was a little kid when I went to Universal Studios. I was also slimed. That was actually probably a highlight of my childhood. I went to Nickelodeon Studios when I was maybe 8 or 9. And I got slimed, and what's interesting, it's actually warm, and you can imagine why, because it's really uncomfortable to have this huge bucket of goo dumped on you. If it was cold, it would not be good. So it's actually they actually keep it like room temperature. It was fairly warm, and it actually tastes good, which is the other part I didn't expect. It was like apple flavored. I was not expecting that, and they make you put on this like a plastic smock and getup. And there's like a shower, so you can go shower it afterwards. It was fine. But you just basically sit in this pool, and the dude runs just like slime. And so that was like, I got a little certificate somewhere in my house. I don't know where. All right, highlight of my childhood, I think, for sure. All right, what else? All right, other questions about, shh, all right, calm down. Questions about property, questions about the curvature and all the other stuff. All right, so let's think actually about problem on page 385. Let's take a look at that one. It's an interesting question. Does anyone remember where I was last week? Good. I appreciate your honesty, Christian. I thank you. So I did you or I didn't do you? Okay, so then she's not. Oh, so you're throwing her under the bus. Okay. You know, it's funny. When I was in the second grade, I said too much personal stuff. When I was in the second grade, the teacher once forgot to assign homework. And it was the end of the day, and actually I was like, what about our homework? And then the bus ride home told me never do that ever again. That was in Brooklyn. These kids are vicious when they're 7. Oh my God. So I never did it again. So Christian, I admire you, but after class, you're getting it. All right. So can you read the question on 385, please? The problem, yeah.
When he died, husband divides the property from his wife to his daughter by the wife.
Okay, so here's the deal, right? You have a husband and wife, right? They're married. The husband gets very ill and says, sweetie, I'm on my way out. If you personally care for me, if you give me this loving treatment in my dying days, for the rest of my life, I will give you this property and will. And she says, of course, honey, I love you, right? Okay, so then he writes her out of the will. And he leaves it to his daughter from a previous marriage. So the wife then moves to challenge this, saying, hey, he made a contract, it's enforceable. What do you think? Is this enforceable?
I would like to believe it would be.
Well, okay, good. So explain, why do you think it would be?
Is that how you do the contracts in consideration? I don't know.
Why would you want this to be enforced? Things that matter like fairness, something. Why do you think this should be enforced?
They had joint property.
So she didn't own this. It wasn't joint. And this is California, so it's from previous marriage. Why would you want this to be enforced? Why?
She shouldn't have rights. They were married and he owned assets
No,
together.
but be very careful. What we're discussing is the promise, right? He promised to give her something that she didn't already have. Why do you want that promise to be enforced? Okay. Eddie, what do you think?
Well, to be fair with regard to justice, but also that by virtue of the fact that when I read this, by virtue of the fact that they're married, there's some kind of unity or some mutual obligation.
Ah. Yeah. If any married people want to raise their hand and discuss whether you think you have some sort of contractual obligation to care for your spouse, married one. Yeah. So is that something you can contract around? Can you say to your wife, hey, if you take care of me, I'll give you this? Is that an enforceable promise? What do you think, Jason?
No, I don't think so. I think as a spouse, you have a moral and a contractual duty to care for your.
Conjugal what? No, contractual. Sorry. Well,
I think
is-
you have a moral and contractual duty, like take care of your spouse and take care of them.
Sonia, what do you think? Is there an obligation for spouses to help? I mean, she mentioned consideration, I think is not a perfect way of thinking about it, but it's actually a decent analogy, right? Is there actually any consideration here, or was this a pre-existing duty? What do you think? Not easy, right?
I wouldn't say it's morally it is pre-existing, but contractually it's the same way that the guy gave the home away, then you shouldn't have to do it.
Right. What could the wife have done instead of taking care of him by herself?
Yeah, she could have just hired somebody. or-
Dumped him in a nursing home?
Exactly, or just, let him do it.
So I think this, yeah, let him die, right? Well, could she have let him die? Could she said, yeah. So who here thinks the court enforced this contract and made them transfer it? Who enforced the promise? Enforced the promise and made the wife get it? 1993. Who here thinks the court said there was no way we're going to enforce this promise? No, we're not going to enforce the promise. One at a time. All right, Liz, what do you think the court did here? Why? What do you think? Ava, you're shaking your head no. What do you think?
I don't.
Why not?
Well, it went to the daughter, and you can't prove it. I mean, the argument between having a duty to take care of him or not is just like very it's kind of moral, not really illegal.
Whoa. So this might come as a surprise, but much of family law is about morality, right? Let's ask this question: when a judge decides which parent gets custody, can a judge consider the morality of the parents? What if one of the parents is more religious than the others? What if one of the parents promises to get to church every week? Can a judge consider that in a custody determination? Whoa, right? Can a judge say, you know what, I think the one of the parents has a girlfriend or a boyfriend and has people sleeping over the house, and I don't think it's good influence? This happens all the time, right? Judges make decisions discussing morality in the context of family law. For those who say morality has no place in our legal system, go to a family court. Gary?
Would it matter what the oaths were? Like,
What the what were?
the oaths. Like,
Oh, their marital oath?
yeah.
The vows, right? I assume they took no vows. It's like, yeah, whatever. They went to Vegas. Elvis married them. Justin?
I'm just curious to know how old is the wife?
Does that matter? It's like an Anna Nicole Smith doctrine.
It's a little sketchy.
All right, so what happened? The court said they will not enforce the promise. Why? Because there's a pre-existing mutual obligation to support the spouses, right? The wife is obligated to care for the husband. And again, yeah, Elise was right. The contract receiver for compensation, there's no consideration, right? You remember from contract, if you're pre-existing to do something, and you make a contract about it, the contract's not enforceable. Remember that from contracts? If you have a pre-existing duty, it said, hey, I contract to do this, contract's not enforceable. And they said it's against public policy, right? They said this degrades the wife and makes her a servant. That is, the wife is expected to then take care of the husband, only in exchange for some sort of a payment. And they said the husband has an equal duty to pay and care for the wife. They said, quote, this is, again, California in 1993, not too long ago, 20 years. This is, quote, antithetical to the institution of marriage. Antithetical institution of marriage. What do you think about that, James? Do you think the court got this one right?
As far as contracts go, they thought it was a pre-existing duty. And they have to look to the will or whatever he divides, and if he passes to his daughter, then I think they have it ready.
No. Do you think it's fair to say that the wife and husband have a mutual obligation to each other?
I'd say so. They ended up married voluntarily.
So what happens in the example someone gave a minute ago, James, if the wife said, screw it, I'm out, I'm not taking care of him, he can go take care of himself. Could a court step in and order her to personally take care of him? Oh.
Probably so, but they probably could take away any interest she would have in property if she everybody wanted to use.
So Andrew, let me ask this question, which we sailing to you soon. If two people have a child and they don't take care of a child, right? Can the court step in and order the parents to take care of the child?
Yes.
Could they do the same? Say for whatever reason you're married, you don't want to take care of your wife. You just stop taking care of her at all. Don't do a thing for her. Could the court step in and force you to be a good husband? Why is there that disparity there?
Because we have an interest in taking care of our children.
But what about spouses? So this is an interesting, asymmetry, a difference, if you will, right? There's an obligation to help the spouse, right? And if the wife does the right thing and helps her husband, she gets nothing for it. But if the wife does nothing, there's no way of forcing her to do it. So if there's this obligation that can't be enforced, but you can't reap the benefits from it. But what is it, to his wife or to his ex-wife? Ah. No. But after they're separated, right? So while husband and wife are married, right, there's virtually no obligation to give anything to the wife. If they're separated or divorced, some sort of proceedings to get the marriage annulled, that's a different story. In fact, that's an important point. The husband only has an obligation to pay stuff to the wife or the wife to the husband, I do it vice versa, after there's a divorce or at the time of divorce, right? Because at that point, she's no longer under his cover. So even though this image of the coverture has been gone for 100 years, while they're married, there's this obligation that can't be enforced because you let them handle it themselves. Now, if there's allegations of abuse or whatever else, different story, right? You can break up the marriage, you can divorce. But abandonment, if a husband abandons a wife, until they get divorced, the court won't order a penny to be paid. Right? You say it's not fair? Why is it not fair?
It's sexist. I mean, why can you make, are you imposing this duty on the wife and not on the husband?
It works both ways. If the wife abandons the husband can't get anything either. See, what's interesting, and this is a broader point, I don't mean to pick on Flora, but there's almost a presumption that it's going to be the husband screwing over the wife. And I think that's somewhat of a sexist presumption because it does happen both ways. Right? So there was a dissent in this case. There was a dissent, right? And the dissent said this is a, quote, outmoded view of relationship, right? What if the wife had a job? And what if she couldn't afford to take the time to take care of him? What if she instead wanted to pay for a house, a live-in aid, right? A live-in nurse. If she had done that, she would have not gotten the property. See, if you said here, it's to personally care, right? And the dissent said there should be freedom of contract, right? Why shouldn't the wife be able to provide care however she sees fit? Again, this was a dissent.
How do they get around tenancy by entirety? I didn't think you could separate.
This land wasn't by the, but this land was not deeded in the tenancy by the entirety.
Right.
If you read it, it's not clear, but if you read the problem, the husband owned it fee simple prior before the marriage, and they never deeded it as tenancy by the entirety. It wasn't even co-tenancy or joint tenancy. He owned it by himself.
But if it was tenancy by the entirety, he couldn't separate.
Well, if it was tenancy by the entirety, yeah, that'd be a totally different story. He couldn't leave it to the daughter because there's a right of survivorship. It would go to the wife when he died. This topic raises a lot of interesting issues of is it actually fair, right? If these laws are designed to shield the husband's debts, right? Or if these laws are designed to make it harder for the wife to collect, what actually are we viewing the role of marriage, right? Is this simply a way of actually being together? Do you have these obligations? or is it a way of just shielding one of the partners from creditors? And the case we do today provides a really thorough overview of this issue. All right, so let's get the parties straight, because the names can get a little bit confusing, because some people have different, the same last names. We'll figure out who's who. All right, so Phil, you're up. All right, so let's high level. What was the tort here? What was the tort that happened in this situation? Okay, so it was a tort of negligence, but describe the facts of the tort, please.
Okay. So Sawada's, they were in a motor vehicle accident. And
Who is the plaintiff and who is the defendant?
Sawada's is the plaintiff, and the Endos are the defendant.
Good. Okay, so you have the two Sawadas, and they're the plaintiff. And then you have the Endos, who are defendants. Okay. All right, so what was the tort? What happened here?
So the Endos hit the Sawadas.
That's right.
And they didn't have insurance.
That's right.
So the Sawadas were going after their personal assets, which was a piece of land.
Good.
And in order to get around that, they conveyed the land by deed to their sons.
Good.
And so the Sawadas are trying to remove the conveyance and obtain the property.
Okay, very good. All right, so here's what happened, right? The Endos got into a car accident with the Sawadas. They caused the tort. They were liable for this tort. Okay? The Endos did not have any car insurance. So generally, when you sue someone without insurance, you're then responsible for collecting whatever assets they may have. Okay? The Endos were not stupid, right? They knew, you guys okay? You right?
Oh, yeah, I'm just, there's only one defendant in the tort.
Oh, because
That was Daddy Endo, and then, so the Endos plural are the defendants because they're the owners of the land.
I'm going to get there.
Okay, all right.
Good. Yeah, if you have questions, raise your hand. All right, so they had this car accident. They had no car insurance, and the Endos knew that the way that these people were going to try to collect was by going after their property. They own a piece of land in fee simple. Okay, so this idea is like, oh, we are so much smarter than them. Here's what we're going to do. We're going to convey this land to our boys. We're going to convey this land to our son, not ours, so they can sue us, but we don't have any property, and they can't collect a penny, right? And what's interesting, they mentioned this in the opinion, is the Endos didn't reserve a life estate for themselves, right? I guess they really trusted their boys. The smart way of doing this was say, okay, I'm giving this life estate for husband and wife, and then the remainder to the boys, right, to the sons. They didn't do that. So I mean, in theory, the sons could have evicted them, but that didn't happen. I guess these were really good sons, right? Okay. I told you never transfer land while you're still living on it, because that means you don't live there anymore. But I guess the sons didn't mind. So as it turned out, the wife, Miss Endo, she died, so it was just left to the husband. So the issue in this case is, was this a fraudulent conveyance? Okay. What do I mean by fraudulent conveyance? If you've been sued and you know you're about to pay a huge damage, and then you deliberately transfer the land to a third party to avoid that judgment, you've actually engaged in a fraudulent conveyance. And courts can actually set aside the fraudulent conveyance. They can actually cancel the sale. So even if they sold it to the boys for zero consideration, there was no money being paid, right? The court can actually cancel it. So the thrust of this case was, should the sale be set aside, right? Can the court set aside the conveyance? The only way that this sale was fraudulent was if the creditors could not reach the interest of the wife, right? So assume for a minute, and this is not the facts, but assume that the husband owned it in fee simple by himself, right? If the husband had owned in fee simple by himself, there would be no. He could have transferred to whoever else, but the creditors could have reached that very easily. Therefore, the court would have set it aside. So, had the husband owned it by himself in fee simple, that would be an easy case of a fraudulent conveyance, and the court would have struck it aside and would have let the Sawadas reach the property for their debt. But this was property titled as a tenancy by the entirety. Did the husband own it by himself? No. But what exactly did the wife have as a share? Right? What exactly was the wife's interest? So this was a common law, right? Before the Married Women's Property Act. We said that basically they own it together as this legal fiction, and there's this third party. In that case, there was only really one owner, and the creditors could have gone after the husband who basically owned the entire property. But the Married Women's Property Act changed things. It now gave both the husband and the wife a separate interest. The question in this case is, can the creditors attach to the wife's interest as well as the husband's? Can the creditors go after both the husband and the wife? And if the answer to that question is yes, then the sale is fraudulent, right? If the creditors could have seized the entirety of the land, they can't transfer it. But if they have separate interests and the creditors could not reach the wife's interest, then this conveyance was just fine, and the Sawadas can't get it.
How important is it that the conveyance was in July, an entire month before he got the summons?
What year?
1969.
And what year was the case? What year was the tort?
1969. So like.
Wait, what, wasn't the tort the previous year? Am I remembering that right?
No, yeah, what was that?
The tort was in '68.
Yeah, but
So they knew it was coming.
Before the complaint was even filed.
They knew it was coming, right? So basically, they got into a car accident. They knew they were going to get sued. Maybe the lawyers had like told them about it and tried to settle, and so they got rid of their only asset to try and avoid that. Yeah. So one issue in the background that's not particularly important now, but you'll study next semester in Property 2, they discuss at the end, is that Hawaii had something of an oligopoly of property ownership. In Hawaii, you had a few very wealthy families that owned virtually all the land, and there was almost no land owned in fee simple. And one of the things the court says is we want to promote family ownership because families can own their land and they can put mortgages on it, whatever. You'll study a case next year called Hawaii Housing Authority versus Midkiff. This is an eminent domain case, which was almost certainly wrong, but I don't get to decide these things. But the court basically said, you know what? These wealthy families have too much land. We're just going to take it away from them and give it to someone else. Yeah, you have too much land. We're going to take it away from you. We'll give you compensation for it. We're just going to take away your land. And the Supreme Court, in opinion by Justice O'Connor, upheld that transfer. What's fascinating is that 20 years later in Kelo v. City of London, Justice O'Connor said, yeah, maybe that opinion wasn't so right. Where she basically dissented in saying that we can't take land from people for economic development. So that's a case almost certainly wrong. It's referenced at the end, but we'll let it slide, right? All right, so let's go back to this case. The question we have to answer is, can this property as a tenancy by the entirety be reached by the creditors? By the way, when I say reached by the creditors, I mean, can creditors actually put a lien on it, right? Can they execute a sale to satisfy their judgments, whatever money they own, right? If the creditors cannot reach it, right, the conveyance is fine. If the creditors can reach it, the conveyance is invalidated. So the court walks through how different states reacted to the Married Women's Property Act. In fact, the answer isn't abundantly clear that what happened as a result of the Married Women's Property Act. So they have these four groups of states of how they've adopted it. And let's try and walk through them one at a time. So Stephen, what was Group 1? How did Group 1 view the interests of husband and wife under the Married Women's Property Act?
They said the common law tenancy by the entirety unaffected by the property act.
What does that mean in your own words?
Basically, we just kept the same, before the property act came out, the same rules that applied beforehand. So, in essence, it would have been viewed as fraudulent because the creditors would have been able to reach.
Why?
Because
Who did the husband and wife have separate interests?
it would have been considered no, they would have had the same.
Exactly. So under group 1, I guess this was Massachusetts, Michigan, and North Carolina. Effectively, the Married Women's Property Act didn't change the tenancy by the entirety, right? So long as the husband and wife were married and you have the 5 unities, you still had this fictional third party that existed. And the creditors can reach the entirety of this fictional third party. In other words, the husband can put in mortgage on the entire interest and not just his share. So in these 3 states, at least at this time, the Married Women's Property Act made no difference. Okay, everyone get that? So because the husband could commit the entire property to being mortgaged, the creditors could have reached it, and therefore the conveyance was fraudulent. All right, now as a historical footnote, all 3 of these states have abandoned this approach. So it's not clear that group 1 exists anywhere, but at least I want you to understand how it existed at the time. Right? Samantha, tell me about group number 2, please.
That the interest of the debtor can be sold.
Okay, so
The debtor can get that portion of.
yes, you're right. So under group 2, does the husband and wife have separate interests?
Yes.
The answer is yes. So even though they're the tenancy by the entirety, and even though you have the 5 unities, the husband's interest can be leveraged by creditors. And if you think about it, this is almost very similar to a joint tenancy, right? We studied last week with a joint tenancy that if one of the parties wants to put a mortgage on his interest, he can do that. You can't touch the wife's interest. So any execution from a foreclosure sale only on one interest, but you can attach one of the interests, right? So at this point, under this group number 2, Shelley, is there much of a difference between a tenancy by the entirety and a joint tenancy? Is there any difference? That's right. So under this group number 2, there's no meaningful difference between the tenancy by the entirety and the joint tenancy. And to the extent that society views marriage as an important institution and they want to give special rights or privileges to couples that title the property as a tenancy by the entirety, this estate, this concurrent interest in these states doesn't really matter. Okay? All right. Carrie, tell me about group number 3, please. This is actually what's called in the majority group. What's the rule of group number 3?
It's basically saying that any conveyance by either spouse is void, and the estate can be subject to separate debts of only one spouse.
Can or can't?
Can. I'm sorry. Cannot. I'm sorry.
Okay.
Yeah.
Which one is it? Cannot?
It cannot.
Good. No, that's right. Okay. So that's right. So what this one says is trying to find this happy middle ground between the Married Women's Property Act and equality. Right? What do I mean by that? Neither spouse can put a mortgage without the other's consent. There are not separate interests. It's still viewed to be the case where the entire property is kind of one interest. You cannot subject the estate to separate debts. In other words, both husband and wife would have to sign up for any mortgage together. If they do it together, you're fine. But the husband can't sign up for a mortgage by himself. More importantly, say if the husband's a debtor and he's a gambler or whatever, and they try and go after his homestead, if it's titled as a tenancy by the entirety, they can't do that. Right? Both of them need to be able to subject their property. Right? Everyone see that? Emily, what do you think about this one? Does this seem fair?
I think it seems fair
To who?
to the spouse,
Why is it fair to the spouse?
because even if, say, the husband is a gambler and has all these debts and stuff, it doesn't affect her because the land is theirs together.
Let's look at this from a different perspective. What happens if the wife wants some money and she wants to put a mortgage on her share? Can she do that? So is it fair?
Not in that situation.
So here's the thing, right? This is actually the point that dissent makes. Everyone keeps assuming the example is a husband screwing the wife over. It's fascinating. Everyone assumes the only possible instance where this law matters is when the husband tries screwing the wife. What happens if the wife wants some money and wants to put a mortgage on her share? Right? What happens if the wife amasses some kind of debt and the creditors want to seize that debt? Right? Why is it simply assumed that the husband's always one screwing over the wife? Now, that's probably statistically more likely to happen. I don't have numbers on this, right? But one of the points the dissent makes is if you want to have equality, take the good with the bad, right? If you want to have equal rights, you take the good with the bad. Sure, the good is they can't come after you if your husband's a debtor, but the bad is that you can't get money from your land. You can't put a mortgage on your land. Your creditors are now screwed. You are now able to take out debt with impunity because your creditors can't come after you. Right? It's this weird asymmetry, and I don't know what gendered biases we have in our minds, that it's the idea that women can gain the benefits of this, but they can't reap the cons. And you know, the majority opinion, which adopts this view from group number 3, speaks of, you know, the marriage as an institution, everyone's together and equal and all this other stuff, but still presumes that neither spouse can make a business decision for himself or herself and actually try and get credit from it. Right, which I think is a somewhat antiquated view. Okay, any thoughts on that? All right, so don't worry about group 4. Group 4 is only in 2 states, and it's basically the same thing as group 2 without any meaningful difference. Don't worry about group 4. In the end, the court adopts the third one. They say that we don't want the husband being able to convey an interest in land he owns by the entirety. Marriage is special, and we shouldn't be diminishing that. Yeah.
Isn't that kind of why they created the tenancy by entirety anyways, by adding the marriage as the fifth unity? Because otherwise it would be a joint tenancy.
So historically, as I started class, why did they create the tenancy by the entirety? What was the reason for it? Coverture. The reason why the tenancy by the entirety was created was to promote coverture, right? This was meant as a way so that women who could not own property as married were able to retain some future interest. The question I asked today is, why do we even have a tenancy by the entirety anymore? Right? Why shouldn't all states choose group 3? I'm sorry, choose group 2, the New Jersey one, and simply say, you know what? If you're married, you can take the pros and the cons of owning property, right? Why do we simply assume that a spouse is incapacitated to mortgage their property because they get married? Or better question is, why would anyone even do this anymore? Why would anyone want a tenancy by the entirety? There's no survivorship's the same, right? All that happens is it says that you can't convey your interest. The tenancy by the entirety says one spouse cannot convey their interest and they can't mortgage it under this figure. Why would anyone even want the tenancy by the entirety anymore? Anyone? What benefits does it actually provide?
Well,
What's the main benefit of tenancy by the entirety?
I would think as you get older, I mean,
Why?
medical bills, things like
Why does that matter? How's that any different than joint tenancy?
Can't,
What is the only benefit from a tenancy by the entirety?
can't give away, like creditors can't come in.
Shielding from debtors, or creditors, right? The only meaningful benefit from a tenancy by the entirety is that creditors can't come after you, which allows one of the spouses to be a spendthrift and the home can't be taken away. But there's significant cost to the tenancy by the entirety, right? One spouse can't sell his or her interest. One spouse can't mortgage his or her interest. It places a severe limitation on how two people can use the property. This is why in a number of states it's effectively been abolished. Right? It doesn't exist in a lot of states because it doesn't really serve much of a purpose. In fact, it does reflect antiquated views of how gender roles manage property.
Can married couples do a civil separation and the separation of property?
Well, once you get divorced, right, the unity's severed.
But can you remain married and do any kind of contractual thing where you can?
Well,
separate
if both parties agree to convey it, they can do that. But both have to agree, right? Right. Here's the rub with the joint tenancy: one spouse can't convey it out. Both have to agree. If both agree, then there's no problem. But very often, when you're trying to move away from your wife or husband from the house, you're probably not in very good speaking terms. So at that point, it gets very difficult to manage property disputes if you don't even want to live with the person anymore.
Tenancy by entirety, you having marriage as the unity. If the marriage, if that unity breaks,
Dissolves, yes.
then you don't have tenancy by entirety.
You have a tenancy in common. Remember, Chutes and Ladders go all the way down.
Right.
Right. So once you get divorced, the survivorship's gone. You're back to tenancy in common. Who else? Anything else? And I think this is the point the dissent makes. And if you go down to the find my notes, right? The dissent basically says that you have to elevate the wife's right to alienate with that of the husband, right? The wife wants to alienate her land. Why shouldn't she? One other note. I guess we're up to Michael. So generally speaking, right? If Mr. Endo had walked into a bank and said, "Hey, here's my land. It's empty by the entirety. Will you give me a mortgage on it?" What do you think the bank would have said to him?
No,
Why not?
because his wife's interest.
Right.
He can't separate that.
Right. So one argument against saying a creditor, when he takes on only one spouse, he should accept the risk, right? If Mr. Endo had any creditors and they knew his land was a tenancy by the entirety, they accepted the risk of having to deal with only one part, right? They couldn't get to the wife's interest, right? Dylan, does that apply in this case? There's the thinking about the creditors knew in advance?
They're coming after it for a settlement.
It's a tort, right? This doesn't work for torts. When the Endos hit the Sawadas, they were injured. They didn't do any due diligence first into the creditworthiness of their tortfeasors, right? They didn't decide, wow, this guy who just hit me, he has his tenancy by the entirety. I can't sue for his wife's interest. So this entire understanding that creditors know in advance, right, doesn't really hold water because this is a tort case. And in a tort case, you take your tortfeasor as you find him. And effectively, they were out of luck in Hawaii. Okay? All right, questions? Someone get the case. So in the end, the court said there was a fraudulent conveyance, right? I'm sorry, there was not a fraudulent conveyance. Yeah, I did this weird thing sometimes where I flip my head yes and no. I actually have to work on it. There was not a fraudulent conveyance, right? Because the creditors could not reach the entirety of the property. They could only reach the husband's interest, which really wasn't separate. Okay? All right, questions on that? Briefly, so one of the interesting aspects of the same-sex marriage litigation has been modifications of state property laws. So the tenancy by the entirety in a number of states has now been expanded to expand to same-sex couples. I actually found this one website in Maryland from some family lawyer saying, "Hey, any of you same-sex couples, retitle your land as a tenancy by the entirety because now you can shield your debt from creditors." Right? And actually the pitch was, if you're in debt and you're a same-sex couple, title it like this so you can get away from the creditors, right? It's a weird application, but it works. One of the other related issues, which I meant to speak about next class, but I'll mention now because we have some time left, has been the sheer velocity with which the gay marriage cases have been going on. So just give you a little bit of background. I don't know if you did these cases in common law yet. but the path to having gay marriage in almost all the states has been blistering fast. So you may not know this, but I think in 1977 or 76 was a case called Baker v. Nelson. You may not have even heard of this case, but in that case, the Supreme Court said there was no right to gay marriage. So what happened? There was a couple in Minnesota, and they tried to walk into the Minnesota County Minneapolis clerk's office. Said, "Hey, you know, we want a marriage license because the statute time said marriage was whatever. 2 people can request a license. Didn't say man or woman. So 2 men walked into the office and said, "Hey, give us a marriage license." And at the time, the Court of Appeals rejected the argument. And the Supreme Court basically said that there was no substantial federal question to be issued. Right? There was no question at all to be resolved. And the Supreme Court dismissed the appeal. Right? So 30 years later, almost 30 years later, we have this case for the Supreme Court, 2 of them, United States versus Windsor, which considered the constitutionality of the Defense of Marriage Act. This other case involving Prop 8, which was an effort by California to ban same-sex marriages after a California Supreme Court decision. This case was decided June of 2013, so basically a year and a few months ago. Since this happened, there's been a torrent of litigation in lower courts, where the lower courts have one after another invalidated state bans on gay marriage. And I include this chart only because I used it when I taught this class 2 years ago. It was projected that it would take about a decade for the majority of the states to have majority of people in favor of same-sex marriage. So, for example, you know, the national average back then was around 48%, wasn't even 50%. So in order to get, you know, most of the states down, you'd have to go till 2020. I think poor Mississippi, right? Even projected that even by the year 2020, only 37% would approve of gay marriages. And here was another poll from March 2013, was right around half that favored it. And since then, it's been frankly stunning. I don't think anyone predicted it. This is a map as of last week, which is effectively changing on a day-by-day basis. One of the most significant Supreme Court decisions this year was one that didn't happen. So on the first Monday in October, when the Supreme Court decision begins, we got this shock. There were 3 petitions for certiorari from the 4th, 7th, and the 10th Circuit involving gay marriage bans. And everyone expected the court to take these cases. And in a stunning development, the court declined certiorari. The client did not take the case. And the effect of declining certiorari was it lifted stays in about 11 states to allow gay marriage to proceed. Since then, the 9th Circuit's ruled, and effectively at this point, only the 6th, which is Michigan, Ohio, Kentucky, Tennessee, 5th, Texas, Louisiana, Arkansas, and the 11th, which is Alabama, Georgia, and Florida, and the 8th as well. So we're down to about 4 courts of appeals that haven't weighed in. The 6th Circuit may issue an opinion any day now. The Texas one will probably be argued in New Orleans, if I had to guess, in December, give or take. And the 11th Circuit came soon. Because the Supreme Court has not shown any interest in actually resolving this issue itself, it's become entirely the province of the federal courts of appeals to invalidate state constitutional amendments regarding gay marriage, which has been a simply stunning development. When I taught this case last year, I would have never predicted we'd be at this stage today. I thought that at some point the Supreme Court would take up the issue, but this has been quite unpredictable. So probably, if I had to guess, when I teach this class next fall, this map will be completely red, if I had to guess. But it's been a really remarkable change. And in a number of states, property laws will have to modify, familial custody laws will have to modify, adoption laws will have to modify, probate laws will have to modify, divorce cases will have to modify. In fact, there's a case pending in Austin at the Texas Supreme Court now. And the issue is you had 2 women, I think they were married in Massachusetts, but I can't remember exactly where. And they now live in Texas. And they want a divorce. So they walk into a Texas family court and say, "We want a divorce." And the judge says, "You aren't married," which provides a problem. So people can't get divorced. You can only get divorced in the state in which you reside. You can't get an out-of-state divorce. So these couple are basically not quite married, but not quite divorced. And it makes custody a really difficult issue because until you get divorced, courts can't issue a custody order. So that case has been pending for about a year and change. And the Texas Supreme Court's been really dragging their feet on that one. So I don't know which will pop first, but I will definitely apprise you of any developments. All right. Any questions? Anything on your minds? No? All right. That's all I got for today. See you guys next week.